Thanks very much for inviting me. The good thing, well, the unfortunate good thing about studying Islam and Islamic law is that it's always in the news. Unfortunately, it's always in the news in the United States for bad reasons. And just a couple of days ago, I woke up in the morning, and lo and behold, Ayaan Hirsi Ali, the well-known expert on Islam, who doesn't know anything about Islam, except for the fact that she happened to be born Muslim, had written a new book entitled Heretic, Why Islam Needs a Reformation Now. I thought this was an improvement because her previous book was called Infidel, and Infidel is actually worse than Heretic, so I thought maybe she's trying to improve her standing amongst Muslims. But anyway, I looked at some reviews of the book, and as usual, there's all sorts of mischaracterizations of Sharia. So I thought, what better prompt to discuss a topic that I find so interesting, that I love teaching about and talking about, namely Sharia. And that is important, probably, when you talk about misquoting Muhammad or misrepresenting Islam, one of the ways in which it's most regularly and often misrepresented is through people not properly understanding the tradition of Sharia. So that's what I'll discuss today. The first question is, what is the Sharia? Sharia in Arabic originally meant the path to the watering hole in the desert, or the path of the tribe, the way of the tribe, the custom of the tribe. In Islam, it becomes the way of the Muslim tribe. And it's best understood probably as the notion of God's law, as the idea of God's law. And it's important you think about it as the idea of God's law, because its manifestation, like all ideas, its manifestation in life is not the same as the idea. So ideas exist in the mind. They don't exist in reality. And when you take something that exists as an ideal and you make it real in the world, you get different representations of that idea. And that's what we see in the case of the Sharia tradition in Islam. It's a tradition of tremendous diversity. And I'll use the word tradition, Sharia tradition, because that's probably the best way for people in the United States to think about it. If you think about American law, which is based on the British common law, there is no one American law. You can't just go and say, you can't go to the library and say, I'd like to check out the American law book. No, you don't. You can go and you can find the law codes of 50 different states, and you can check those books out. But even those don't represent the laws of each state. These represent the statutes passed by the legislatures in those states. There's also the law that's just the judge-made law, the law that judges manifest and represent, namely the actual common law. So even American law, it doesn't exist as one thing. It exists as a tradition, as a legacy that's passed on and manifested here and there in different ways. And everybody knows what you're talking about when you mention it, but even if you can't go and point to one thing, it is American law. So I'll refer a lot tonight to the idea of the Sharia law tradition, or the Sharia tradition. The Sharia is tremendously diverse for a number of reasons. One, because it's based on sources, the authenticity of which are disputed. The authenticity of which is disputed. What does that mean? To put it very simply, and this is something that you could talk about for a long time, to sum it up, the Sharia is based on several sources. Two of them are believed by Muslims to be revealed sources. So they come from God. The first one is the Quran, the actual revealed word of God in Arabic to the Prophet Muhammad between 610 and 632 when he died, year 632 of the Common Era. The Quran is a very small book. Many Muslims memorize the whole thing, word for word. It's not that small, okay, but it's not the Bible. It's like a fourth the size of the Bible, or a fourth the size of the New Testament, I think. So you can, but it's a challenge to memorize the whole thing, don't get me wrong. But the Quran is not really a book of law. In fact, most Islamic law, most of the details of the Sharia don't come from the Quran. They come from what's called the Sunnah of the Prophet Muhammad. The Sunnah of the Prophet Muhammad is his authoritative precedent. It's his living explanation of the teachings of the Quran. It explains the Quran, it adds to the Quran, sometimes it modifies Quranic rulings. So the Quran tells people how to pray. It tells people to pray. It tells Muslims that they should pray. It doesn't tell them how many times they should pray. It doesn't tell them how to pray. It doesn't tell them what to do if you make a mistake in the prayer. Right? This stuff all is taught by the Prophet. Now, Muslims don't dispute the authenticity of the Quran. It's agreed upon, its text is agreed upon by all Muslims. It has been since around the year 650 of the Common Era. They do, however, disagree on what constitutes the Sunnah of the Prophet. Because unlike the Quran, the Sunnah of the Prophet is not written down early on. It's transmitted sometimes in kind of primitive written form. It's transmitted orally. It's transmitted through custom and tradition. And it really remains to this day a body of knowledge that is between oral and written form, between written books describing what the Prophet said or did on a certain occasion, the way he ruled on a certain case that was presented to him. And it's also lived in the practice of the Muslim community and in the problem-solving methods of Muslim scholars, as it has always been. So, because the Sunnah is much more amorphous than the Quran, it's parts of it are disputed by some Muslims and parts of it are disputed by others. So some Muslims would believe that the Prophet, let's say, said that all deeds are determined by intentions. Deeds are determined by intention, so by your intentions. So if Muslims who believe that the Prophet said this, and believe that's an authentic report from him, would believe that if you don't have the intention of making ablutions before prayer, your prayer is invalid because your ablutions aren't valid. Whereas Muslims who don't believe that saying of the Prophet is authoritative or authentic would not consider intentions to be essential for doing ablutions before your prayer. So there's diversity in the Sharia tradition from the beginning because there's disagreement over some of its constitutive sources. Finally, the third overall, and this is a big source, is just human reason. And when I mean human reason, I don't mean necessarily logic or what somebody thinks is reasonable. Reason is just the activity of the human mind. Whether it's the activity of the human mind set to interpreting the Quran or the Sunnah of the Prophet, whether it's specific rational tools that Muslim scholars develop, like analogical reasoning. So if you say that, just to be really detailed, right? If you say that human blood is, once it leaves the body, it becomes ritually impure. So if you get blood on you, it's like ritually unclean, or like even animal blood. You have to wash that off in a specific way. Okay? Well, what about other bodily fluids? What about, for example, breast milk? Is breast milk ritually impure? And this comes into the issue of can a woman buy and sell breast milk? Let's say you're nursing a child, you're not producing enough breast milk. In theory, you can't buy things that are ritually unclean. So, by analogy, if you think of breast milk as a bodily fluid like blood, then breast milk would be ritually impure, and you couldn't buy it and sell it. But you're going to have a lot of problems with women who don't have enough breast milk to feed their child, and back then they didn't have formula. So scholars use another rational tool, which is called istihsan in Arabic. In English, it's best understood as equitable reasoning, which is, you can see that this analogy is leaving you with a kind of unjust result, so you find another way to get to a just rule. In this case, they would say necessity requires that people be able to get breast milk for their babies, otherwise their babies are going to die. And so in that case, you would say necessity makes this then permissible. So these are some of the different kind of rational tools that Muslim scholars use in deriving the rulings that make up Islamic law. As an example of the diversity caused by interpretation, you can take the case of how, this comes up in the news a lot, how Islamic legal scholars viewed places of worship of non-Muslims living under Muslim rule. So churches and synagogues of Jews and Christians, or temples of Hindus and Buddhists living under Muslim rule. The one method of interpreting, let's say, a verse from the Quran, treats it as an exclusive text. So the Quran talks about Jews, Christians, a group called the Sabians, no one really knows who they are. Okay. It talks about these groups as people who receive revelation before Islam. Groups who have, although their religion has been, from the Muslim perspective, corrupted, their religion is based on revelation from God. So Jews, Christians, and this group called the Sabians. Now, if you believe that when the Quran mentions these groups, that's all the groups that could have this status, that's one approach to the text. So you can imagine if I say, bring me an egg salad sandwich, a tuna salad sandwich, and a brownie. From this perspective, it would mean, do not bring me any pieces of fruit or one of those oatmeal cookies and no drink. The other perspective would be, the other interpretive approach would be, if I say, bring me an egg salad sandwich, a tuna salad sandwich, and a brownie, I might also want a oatmeal cookie and a drink and some fruit. And we should be open to that possibility. So the majority of Muslim scholars understood that Quranic list of these groups that were legitimate religions who could practice and retain their religion under Muslim rule. They thought that this list is not exhaustive, that it's just a listing of a few groups, and any other group you come across, like Hindus and Buddhists and Zoroastrians, they're also allowed to continue to practice their religion under Muslim rule. And this is the majority opinion of Muslim scholars. The other approach, which was the minority, would say, no, this is an exclusive group. So if you come across Hindus or Zoroastrians, they don't meet that criteria. Similarly, what about repairing or building churches or synagogues? So if you're, let's say, the Muslim rulers of Baghdad in the 1000s, and there's lots of synagogues and churches in Baghdad, what happens if the Jewish community wants to build a new synagogue or wants to repair an existing synagogue? One approach to reading the Quranic text says, the Quran mentions that if God did not use one group of people to oppose another group of people, then many synagogues, monasteries, and churches and mosques where the name of God is mentioned would be destroyed. So it talks about synagogues, churches, monasteries, and mosques as being places, all being places where God's name is mentioned, and this is a good thing. So from that perspective, you would say, even if, as a Muslim, you don't agree with Christianity, you don't agree with Judaism, you don't agree with Zoroastrianism, the people in those churches and mosques and synagogues and fire temples are honoring God in whatever way they believe subjectively to be the correct way. And if that's something that's inherently good and therefore it should be promoted. So they can build new mosques, new temples or new synagogues or repair existing ones. The other perspective would not look at that angle, would say, wait a second, these other religions are engaging in practices that Muslims find religiously unacceptable, and therefore it's wrong for us to sanction those practices by allowing them to rebuild, or build new places of worship. You can see it's not that these two approaches they're both reading the same sacred scriptures, but they're coming at it from different assumptions. One assumption is sort of honoring the subjective worship of God, and the other one is concerned with not allowing practices and beliefs that Muslims don't agree with. Finally, a very important cause of diversity in the Sharia tradition is the tremendous geographic diversity of Islamic civilization. So Muslims, within 100 years or 150 years of the death of the Prophet Muhammad in 632, Muslims are in 711 they enter the Iberian Peninsula. The same year they also begin the conquest of India. In 750 they reach Inner Central Asia. And over the next centuries, Islam as a religion and Muslims as a community spread through Southeast Asia, China, Sub-Saharan Africa, the Balkans, and then in the 20th century to Europe and to the United States. So Muslims live and follow the Sharia in a tremendous diversity of geographic locales, different cultures where there's different customs, or people have different needs. So the Sharia is constantly adapting to these local situations, and you get also tremendous diversity. So a good example of this would be in one of the Sunni schools of law, the Hanafi school, which is the most numerically numerous, largest school of law in terms of followers, which is almost all the Muslims in South Asia are Hanafis. Now, in the Hanafi school of law, you cannot eat anything that comes out of the water, any sea creature, except fish. Except fish. Now, is anybody here from Bangladesh originally? Oh, from Bangladesh, okay. Yesterday I gave a talk at Sunni Stony Brook, and almost the entire audience was Bangladeshi, so unfortunately, clearly we have a different representation here. Bangladesh is a country that's just surrounded by water inside and outside. And Bengali Muslims eat lots of things that aren't fish that come out of the water, even though they're technically Hanafi Muslims, because that ruling just wasn't going to last. It wasn't meeting the standards of the needs of Muslims in that community. Similarly, Muslims today in Europe and the United States are theoretically, ideally in Islamic law, Muslim men and women would not shake hands with people of the opposite gender. But because this is culturally essential in Europe and America, Muslim scholars and scholarly institutions in Western Europe and North America have generally said that it's permissible for Muslims to shake hands with people from the opposite gender, because this is a part of local culture. There are certain aspects of Islamic law that are not going to adjust to local culture, because they're very specifically stated in the Quran or the Sunnah of the Prophet. For example, alcohol is prohibited. Alcohol is prohibited in the Quran. So you're never going to go to a place, let's say you come to an American university where students love to drink and it's part of the culture. Or you go to Boston and you live next to an Irish pub and you feel it's part of local culture to drink beer. That doesn't matter. That's never going to overcome the textual prohibition on drinking alcohol. So there's certain fixed points in Islamic law that are never going to change, but a lot of the details of the contact surfaces of where that law and life meet, they will change based on local needs and local cultures. So the tremendous diversity of the Sharia leads to numerous schools of law forming in the early Islamic period. And these schools of law some of them become extinct, some of them don't become very popular for a variety of reasons. And basically by the 1100s or 1200s of the Common Era, in Sunni Islam you have 4 schools that survive. In Shiite Islam you have 2 schools that survive. You also have the Ibadi school, which is found only in Oman and parts of Algeria, which is another sect of Islam. But so these schools have tremendous internal diversity, both within each school, but also amongst themselves. So you have, when anyone says the sentence Islamic law or Sharia says X, that sentence is almost always automatically incorrect. Because there is almost always more than one opinion on Islamic law, more than one ruling from Islamic law on any issue you can imagine. From how you pray, to whether or not you can eat certain foods, to whether or not you can engage in certain kind of financial transactions. There's always more than one opinion. And so I think, again, American law is kind of a useful analog, because we all understand that American law is one unified tradition. But if someone asks you, let's say there's a tree growing in my neighbor's yard, and it's dropping these stinky berries onto my house and onto my yard, and the roots of the tree are going under my deck and pushing up the stones, what can I do? What's my legal remedy? And if you ask a lawyer, what they'll tell you is, it depends on which jurisdiction you're in, it depends which state you're in. The rules of Virginia are very different than the rules in Hawaii, very different than the rules in Maryland. Some states allow you to go and chop that part of the tree down. Some states say if the tree is harming your property, you can do something about it. Some states say, no, a living thing, if it's naturally occurring, you can't do anything about it. So we know that there's tremendous diversity in the actual rules of American law. But we think of it, we understand it as being one unified tradition. That's the same way with Sharia. Perhaps the most important, I didn't put this first, perhaps the most important distinction that to keep in mind when you're thinking about the Sharia as opposed to, let's say, Western law or American law, is that the bulk of the Sharia, the bulk of its rulings, subjects that are dealt with under the Sharia, will never see the inside of the courtroom. They are not things that people actually, we would think of as law, as disputes between people. They involve things like ritual purity, performing ablutions for prayer, fasting, pilgrimage to Mecca, giving charity, manners, treatment of your relatives, how you dress, how you sleep, how you eat. So these are all things that in the United States we would consider either ethics, personal ethics and conduct, or matters of personal religious practice. But if you take a book where a Muslim scholar has actually tried to set out what their vision of the Sharia is, Islamic law is, if you have a book, let's say 12 volumes, which is not an unusual size book for Islamic law, 12 volumes. Probably the first two volumes are going to be ablution and prayer. Then you're going to have a whole volume on fasting, a whole volume on pilgrimage, a whole volume on marriage and divorce, and a volume or two on sales transactions, irrigation of fields, business partnerships, lending, mortgages, everything you can imagine. And then you'll have a volume on personal behavior, on laws of war, things like that. And actually, only a few of these subjects are things that would actually, you would take to a court, to a Muslim court. Most of it is stuff that is never going to, a judge wouldn't even know what to say. You go to a judge and say, I am taking myself to court because I don't think I'm praying again. That's ridiculous. No, these things are never going to go before a judge. But it doesn't mean that they're not in the most important areas of Islamic law. So here you have to think of Muslim scholars who in many ways are equivalent to, it's actually kind of ironic, but they're like rabbis. They're not, Muslim scholars, the clerical class of Muslims, are not akin to priests in the sense that they don't perform sacraments, they don't perform a mediating role between man and God. They're like rabbis, in that their primary job is to study the sacred scriptures of their religion and to guide the Muslim community, to guide their followers, their flocks, towards a proper understanding of God's will. They don't have formal process of ordination. You become a Muslim scholar when you are viewed as a scholar by those around you. But these these scholars can and have historically served in two very important capacities. One is as a judge, sitting in a court where they'll actually be doing things like applying laws of contract, and people coming and getting disputes over buying and selling things, over land. And the other thing is to the role of muftis. And a mufti is a Muslim scholar who is just giving, mufti is a Muslim scholar who's just giving his opinion on a matter of Islamic law to a Muslim. And it's a non-binding opinion. And this is where you get things